As a consumer bankruptcy attorney, one of the questions I get asked quite frequently is, if a judgment or a lawsuit has already been filed, is it too late to file bankruptcy? Well, absolutely not. In fact, that's the reason most people file a bankruptcy case, is because some type of legal action has been taken against them. The thing to remember is that if the underlying debt is dischargeable, then the filing of the lawsuit or the entry of a judgment does really nothing to impact that dischargeability of that debt. So if a credit card company has filed a lawsuit against you or actually gotten a judgment, that debt, being a dischargeable debt in bankruptcy, would still be dischargeable, and you could file bankruptcy to eliminate that debt. Now, what I do is I file, once the bankruptcy case is filed, a suggestion of bankruptcy. It's a document we file in the state court proceeding to let all parties know in the state court that a bankruptcy has been filed, the automatic stay injunction is in effect, and they can take no further action on that case. Now, if a judgment's already been entered, another key concept that's often overlooked is to file a motion to avoid a judicial lien. And this is a code section under the bankruptcy law where if the property is exempt, such as homestead property, you can file a motion to obtain an order avoiding that judgment lien. One of the biggest mistakes young attorneys make is they include the debt in the bankruptcy filing, the judgment's been entered, but they do not file a motion to avoid the judicial lien. Once that order is entered, you can record that in the public record, and that will actually clear up title. So if the homeowner later goes to file or sell their property, they can discharge, evidence that discharge of debt and the removal of that lien. Many cases are reopened because the attorney fails to file the motion to avoid the judicial lien, the judgment lien, and actually get an order and go record it. So just because you list the debt and just because the debt's discharged, if a judgment has been entered, you have to take that extra step. But in general, it's never too late to file bankruptcy if a lawsuit has been filed or a judgment entered. In fact, the automatic stay provisions of the bankruptcy code stop everything. And that's one of the biggest reasons people file a case, not only to get relief from debt, but to stop lawsuits. So if a lawsuit's been filed against you or a judgment's been entered, if the underlying debt is dischargeable, it's not too late. You can file a bankruptcy case and discharge that debt legally.